Our speaker, Sarah Matsumoto, is a clinical associate professor and director of the Getz Green Natural Resource and Environmental Law Clinic at Colorado Law. Sarah has previously directed and taught in environmental clinics at Willamette University College of Law in Salem, Oregon, and the University of Denver Sturm College of Law. In the law clinic, Sarah works with teams of students who advocate on behalf of individuals and communities seeking to protect themselves from environmental harms. She also works with clients seeking to better engage and collaborate with local, state, and federal agencies to solve pressing environmental problems. Sarah began her legal career as a public interest attorney in Oregon, where she worked with clients to enforce the Clean Water Act and the Resource Conservation and Recovery Act. Sarah writes about environmental justice, particularly in the context of water quality and extreme heat, and has published articles in the University of Missouri, Kansas City Law Review, Pace Environmental Law Review, and the Alaska Law Review. Her current project, presented to the 2024 Sabin Colloquium on Innovation Environmental Law Scholarship, examines federal land exchanges and the concentration of land ownership among ultra-wealthy individuals in the western United States. Sarah is coming to us tonight to talk about a recent Supreme Court decision that has an impact on something called the Chevron doctrine. And she'll explain all of this, I think, in much greater detail and certainly and with much more knowledge than I would be able to do that right now. But it has a profound impact on the regulatory agencies and the way in which they relate to natural resources and public lands. We are really blessed here in Mesa County. For those of you that are fairly new to CMU as students, Mesa County has 72% of the county that we're in is actual federal public lands. So it has, this talk tonight has huge impact, or the subject matter rather of the talk tonight, maybe the talk too, will have huge impact on what we do, how much we love to be here, and what we can see. So without further ado, would you please help me welcome Sarah Matsumoto.
Thank you so much, Tim and Elliot and everyone else who was involved in kind of facilitating this conversation. It's really such an honor for me to be here with you and share some of my thoughts and my work. And I'm especially pleased to see so many students here. One of the reasons that I really gravitated towards clinical teaching and working actively with students in the representation of clients is because I draw a lot of inspiration working with students. And you all, your energy and your interest in these really important subjects really motivates me. So I appreciate your attendance tonight. Just to give you a little bit of a roadmap of where we're headed, I'll tell you a little bit more about kind of myself and my interest in these subjects. We'll start with some fundamentals. 3 branches of government, go through a little bit of kind of what these agencies are, what they do. And then I'll get into the case that was overruled, the Chevron case itself, just give you some facts about it, what it was looking at, the doctrine that emerged from that case. And then I'll talk more about the Loper-Bright case, the more recently decided case that kind of undid everything Chevron did back in the 80s. And then finally, to conclude, I will do my best to give you a sense of what this all might mean, particularly for environmental law, natural resources, and public lands. As I suspect you may conclude or start to conclude, it's a little messy and it's a little bit kind of tough to tell how everything will shake out. But there are a few things that I think we can pretty safely assume coming out of the Supreme Court's recent decision. So starting with a little bit more about me, thank you again so much for that kind introduction. I just wanted to share, especially since there's so many students here, how I kind of came to be interested in environmental law. That word or that phrase has kind of 2 components. For me, I really started with the environment. I was interested in the outdoors. I grew up in central Washington on the dry side of the state and was really lucky to have a grandfather who loved fishing and loved spending time outdoors and loved to bring me along with him. And so that's really where my interest in being outdoors, learning about the natural world, appreciating why it's important to try to work to kind of steward it and protect it in a way, not just for us, but for all the other species that kind of depend on the natural world. That's what led me to environmental law. I was kind of thinking about, here's what I'm interested in. I'm interested in the environment. I don't really know how to turn that into a career necessarily, but I was lucky enough to have some undergraduate professors who really encouraged me that there is actually this whole body of law called environmental law, and you too, if you're interested in it, can kind of become one of those people. So I just share that with you kind of by way of background. So starting at the beginning, what are agencies? Why should we care whether or not agencies have authority to do anything? You all, I'm sure, already know this. The federal government has kind of three distinct, co-equal, in theory, branches: legislative, executive, and judicial. The legislative branch is Congress. Those are our elected officials who are tasked with thinking about problems to try to solve and then solving those problems by writing laws. Congress may have to write laws on any number of subjects with any degree of complexities and kind of technicalities. And as you can imagine, that task, it's difficult for a number of reasons to agree, to come to compromise on what the law actually should say. And then trying to anticipate every little potential issue that might come up 10, 20, 30, 40 years down the road can be really tough to do, especially in areas where there's new and developing technology, in the area of environmental law, where there are factors sort of beyond our control that might make an issue kind of in need of some attention through a statute or through regulation. So that's Congress, their job, writing the laws. Then we have the executive branch. That's generally, the president, who is tasked with executing the laws, hence the name executive. So it's their role to kind of take these laws that Congress writes and figure out a way to kind of put them into action and enforce them. And as you can imagine, that is a pretty large task. If the president were doing it alone, even with the help of kind of their close advisors, it would be, an insurmountable task. Hence, the reliance on this kind of almost fourth body called administrative agencies. So if you've heard any of the alphabet soup of agencies, EPA, FDA, any number of agencies, they are tasked with kind of supporting the executive in implementing the laws. So those agencies, in the course of their work, do their best to understand what Congress said and then try to put it into action in some way. That usually involves taking additional steps. So maybe they have to think about what an unclear word might mean, which will be the focus of a lot of my remarks tonight. Or maybe they have to come up with additional processes. Congress said, do X or regulate X, and it's up to the agency to figure out how we're actually going to do that. Third branch of government, the judiciary or the courts. And these, at least at the federal level, judges and justices are appointed for life, and the idea is that these lifetime appointments in the federal judiciary help to eliminate any chance that the judges might be influenced by politics. You can imagine how if you had to run for office, like other branches of government, you might feel some pressure to interpret the law in a way that might enable you to get reelected. But the idea with having these lifetime appointments, again, at least in theory, is that judges would have some freedom to really, truly exercise independent thought, and when they are tasked with resolving a dispute and interpreting and applying the law, reach the best outcome, kind of free from political intrusion or interference. So that's the idea of how things are supposed to work, and that's where an agency kind of fits in, helps with that executive function of implementing and enforcing the laws. So around the New Deal with President Roosevelt, there was a real rise in administrative agencies. A lot of these New Deal programs and policies were pretty dependent on agency function to help carry them out. That led to, eventually in 1946, Congress, maybe being a little overwhelmed, wanted to clarify how agencies would function, kind of situate them within the role of the other branches of government, and Congress passed the Administrative Procedure Act. This law tells us how agencies are to adopt new regulations, how they're to adjudicate disputes that perhaps come before them. So for example, if I apply for a permit from a particular agency and get denied, a lot of agencies have kind of an adjudicative appeal process that I can follow. And this act generally gives us the contours of what that's supposed to look like. Importantly, it also provides for judicial review of agency actions. So what that means in a nutshell is that this act says, if someone is injured or aggrieved by what an agency has done, that person has the right to go to court and say, Your Honor or Your Honors, please help me resolve this dispute. The agency did something that I don't agree with and it kind of harms me in some way. I'm hoping you can give me some recourse. Sometimes they win, sometimes they don't. So the Administrative Procedure Act has been around since 1946. Like I said, it gives us these kind of basic structures and processes. And so for a while, for a number of decades, litigants kind of went along and courts would do their best to sort of muddle through and figure out, oh gosh, was the agency right in this case or was it not right? Did they kind of act in accordance with what Congress seems to have indicated or did they not? And then finally, in 1984, that's when we arrive at the Chevron decision itself. Some of you may have kind of heard about the doctrine or the two-step. I want to set it up a little bit with the facts, because I think that really helps to illustrate it. And also, as an environmental law person, it's always fun for me to talk about this case a little bit. So in 1984, the EPA was looking at how to implement a part of the Clean Air Act. So the Clean Air Act, one of the big major federal statutes that helps us try to protect and maybe improve air quality through a number of different programs. Some of those programs maybe deal with vehicle emissions, so there are standards for new vehicles. This particular program was looking at emissions from so-called stationary sources. This is just what they sound like. Instead of being moving sources, these are fixed facilities like think a coal-fired power plant or some other sort of factory, some fixed place. And as EPA was kind of looking at how to regulate these fixed or stationary places, it was really grappling with what the word source means. Think to yourself for a minute, what does the word source mean? And then I'll give you kind of the two options that they were considering, just to give you a sense of how difficult it is to kind of resolve some of these ambiguities. So under approach A, over here, one way that EPA could regulate sources is to look at a factory or a power plant and to look at the number of maybe boilers or kind of generating stacks that the facility has and count them up. And each one of those would be a source. There's some support for this. The Act talks about regulating emissions from all sources. And so let's say over here in our approach A, the coal-fired power plant maybe has 3 sources, 3 boilers that all give off emissions that contribute to air pollution. Approach A, 3 sources. Approach B is a little different. So approach B, the EPA could look at that same power plant, look at the individual boilers or stacks at that facility, and then what it could do, just kind of for maybe regulatory ease, would be to envision an invisible magic bubble over the facility and say, well, this entire power plant, sure, you've got your 3 stacks, but if we put this kind of invisible magic bubble over it, we can just count you as 1 source. Maybe you're part of the same company, all these sources are working towards the same thing. We'll put this bubble over it, you'll be 1 source. So approach A gives us the 3, approach B for bubble gives us the 1. And in the 80s, under President Reagan, there was a general trend towards deregulation. So kind of getting rid of regulatory complexities that a lot of industry actors really didn't like because it either made it more challenging or more expensive for them to generate income and to kind of carry on the business that they wanted to carry on. So a lot of industries really favored this bubble approach because that was just 1 source and would be less costly and maybe just a little bit more easy and efficient on their part to deal with in the course of their business. So those are the approaches. The Reagan EPA chooses approach B. It likes the bubble approach, moves away from what the prior administration under President Carter had done with a little bit more kind of protective regulation. It says, look, we like this bubble, this is what we're going with. And as you can imagine, a number of parties didn't really like that, including a lot of environmental groups. One that you may have heard of, the Natural Resources Defense Council, or NRDC. That group, along with a number of others, kind of challenged that decision and said, we don't think that that decision aligns with the text of the act and the purpose of the act. We think that the other approach, where you count those individual stacks or boilers, makes more sense. Industry groups like Chevron and others intervened on the side of EPA to say, no, this bubble really works for us. This is the approach that we want. It's deregulatory in nature. It's more pro-industry. This makes sense for us. So that's kind of how we set up the dispute. At the Court of Appeals, the environmental groups won, and the court said, yeah, we think that the EPA made a mistake here. We're going to rule in your favor for kind of the more protective approach. At the Supreme Court, the justices really were going round and round, back and forth, with trying to figure out, what does source mean? There kind of seems to be maybe support for multiple interpretations. It really isn't clear. And that's where the Supreme Court kind of gave us what came to be known as the Chevron doctrine, or the Chevron two-step, sometimes it's called. But it's this analytical framework to figure out when an agency has kind of acted in accordance with its charge from Congress, lawfully, I guess is another way to think of it, and when the agency has kind of maybe gone out of bounds with a particular action. The two-step is as follows. So the court will first ask the question, did Congress speak clearly and directly to the question at issue? So the court will kind of look at the statutory text, maybe look at the legislative history to figure out, is this statute clear about what the agency should do or not do? And if the answer is yes, that's it. The court's inquiry ends, and the court says, Congress was pretty clear to us. It seems like, agency, you are supposed to do A, B, and C. We can see that clearly in the statute. In this case, you chose to do D. And so we're not going to defer or kind of respect the decision you made, and we're going to send you back to say, please do it again. But if you did A, B, and C, and the statute says A, B, or C, then that makes sense. You're acting kind of in accordance with Congress's clear expression of delegated authority to you. Gets a little messier if we get to step two. So if the court kind of asks the first question in step one, did Congress speak clearly? And the answer is no. Maybe Congress didn't say anything about what the agency has done. Or maybe there are ambiguous terms, like the word source. Does source mean individual boilers and stacks, or does source mean the entire facility? What does the word into mean in the Clean Water Act? What does the word from mean? Some of these ambiguous terms that maybe could be interpreted different ways means that we need to do a little more exploring. And so if the court reaches that second step, that step two, it will look to see if what the agency did was sort of reasonable or permissible. Importantly, the court will not substitute its own judgment. So the court might say, those of us here on this judicial body, we maybe would have done something different, but we can at least see why what you did makes sense in the context of the statute. We also think it was generally lawful. You weren't kind of going way outside the bounds of your authority. And so as long as what you did, agency, is reasonable or permissible, we will defer to you. So that's what gives us that Chevron doctrine, or the Chevron two-step. Once again, first question, did Congress speak clearly and precisely to the issue at hand in the statute? If so, inquiry's over. If not, you go to step two. Is what the agency did in this case reasonable and permissible? If yes, deference is owed. If not, the court will kind of send them back for some sort of a do-over. So that's the framework that came out of Chevron. A couple interesting things to note. The Supreme Court has 9 members, 9 justices. 3 of them, for whatever reason, didn't participate in the decision. So Chevron was decided by 6 judges. And it was written by Justice Stevens, who kind of in memoirs or speeches after the fact said, you know, I didn't really expect that Chevron was going to be this major cornerstone of administrative law. I didn't know that that's kind of where it would end up. I just thought we needed some sort of analytical framework to resolve these problems, because we were getting a lot of questions about agency decision-making in the context of their delegated authority in the statutes. Chevron initially was supported by conservatives because after applying the framework, the court said, we think that EPA's bubble approach over here, just treating it as one source, is reasonable or permissible. And so in that case, the court found in favor of the kind of deregulatory pro-industry interpretation. And so folks who kind of tend to support industries or oppose regulations initially cheered the decision. But over time, as Chevron was kind of implemented, and it frequently would defer to maybe more environmentally protective or more pro-regulatory types of decisions, those same people began to get pretty frustrated with the framework. And eventually, there were efforts begun to really think about, from a legal standpoint, how can we chisel away at this decision and hopefully undo it eventually? That brings us to the recent case from last term, Loper Bright Enterprises versus Raimondo, the Secretary of Commerce. It was consolidated with another case. I'm generally just going to speak about Loper Bright, but just know that the decision actually was the result of two consolidated cases. And Loper Bright, not to spoil anything for anybody, but it overruled Chevron. I'm going to spend a little bit of time talking about why the majority held and concluded the way that it did, talk about a couple concurring opinions, and talk about the dissent. So out of those 9, whenever the court gets to a 5-justice majority, that becomes the opinion of the court. Other justices are able to kind of express disagreement or partial agreement, but for different reasons, in opinions known as concurring opinions and dissenting opinions. So that's what I'm going to take you through here. Just a little bit of procedural and kind of factual background about the case itself. In 1976, the Magnuson-Stevens Fishery Conservation and Management Act was passed by Congress. And this was kind of in response to some concerns about degradation of fishery resources and the understanding that in order to kind of sustain them into the future, some sort of management was warranted. Part of this act delegates from the Secretary of Commerce authority to an agency known as the National Marine Fisheries Service. That's the agency that's tasked with kind of executing. Remember, think back to that framework about where agencies fit in government. They're tasked with executing the act. And so one way that they do this is administering what's known as fisheries management plans. These plans get adopted and promulgated as official agency rules. And those plans, some of them require some type of observer to be on board certain types of vessels. The facts ultimately aren't super important to the opinion, but I just want to give you a sense of how we got here. So these observers are required to kind of ride along on vessels for certain kind of fishing excursions. Those observers are sometimes funded by the government, sometimes paid privately, just depending on some of the circumstances at issue. And so for a couple companies, they didn't like that they might have to pay the cost for these observers, kind of third parties, to come along on their fishing vessel. So the point of the observers is to maybe collect data, generally considering the health of the fishery separate from the commercial fishing vessels who are there to catch fish. So these two different companies challenged the rule that mandated these observers, and they both lost at courts of appeal. So there were two separate challenges, two different courts of appeal. They lost, and then petitioned for certiorari. That's where you kind of formally ask the Supreme Court, we have this dispute, please take our case. The Supreme Court gets tons and tons of petitions for cert every year and really only grants a small fraction of them. So in this case, the petitioners added to their potential questions presented that they wanted the court's opinion on, they raised Chevron and said, well, in addition to helping us figure out whether this rule requiring observers is lawful and something we have to just kind of accept and deal with, maybe, court, this is a chance for you to revisit this doctrine that we know many of your members kind of grumble about and really don't like. And the Supreme Court said, thank you so much for the invitation. yes, we would love to hear that question, but we're actually not going to accept cert to consider the other questions about the observer on these fisheries vessels. Sorry, you're out of luck. We're not going to consider that question. We do really want to get into Chevron, though. So that's how it got to the Supreme Court. And I will tell you that once the petitions were granted for the Supreme Court to hear this case, I think a lot of people who follow administrative law or agency practice or the Supreme Court in general thought, oh, Chevron is not long for this world. It's probably just on borrowed time. And the question will be just how much the court chips away at Chevron. And maybe it's going to throw the whole thing out. So the court did exactly that and said Chevron is overruled. The majority opinion was written by Justice Roberts, and he gave a few reasons why he said that Chevron needed to go. So the first reason is, remember the APA, that's that law passed in 1946 that kind of responded to the New Deal proliferation of agencies, gave us some procedures that agencies follow, and provided for judicial review. Justice Roberts says, well, importantly, even though Chevron was decided in 1984 and has been on the books for 40 years, and I've cited to it, and everyone on this court has probably cited to it and understands it, it actually has been inconsistent with the APA this whole time. So that's one reason that Chevron needs to be overturned. And Section 706 of the APA says the following. I typed it out because I want to make sure that I get the quote right. But it says, to the extent necessary to the decision and when presented, the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. And Roberts really focused on that provision and says, well, the APA says that the reviewing court is supposed to decide all relevant questions of law. And in my view, all means all, and that means this is the province of the court. And so these agencies that are deciding some of these questions, they're really kind of stepping outside their function. This is the province of the court, and the APA kind of tells us that the court is supposed to be the one carrying out this function. In this kind of same section of the decision, Roberts also says that Chevron relied on a presumption that is just fundamentally incorrect. He says that the presumption was that when Congress left an ambiguity in a statute, it understood that the agency would probably be the one to resolve that ambiguity, and in fact, it maybe even desired the agency to resolve the ambiguity. Roberts says that that presumption is just wrong. We can't presume that a statutory ambiguity somehow is like a quiet or implicit delegation of authority to agencies. He says, in an agency case, as in any other, there is a best reading, all the same, the reading that the court would have reached if no agency were involved. So once again, reminding everyone that this is really the province of the court, in his view. He says this presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. We are going to come back to that question of who really has the special competence or special expertise to resolve some of these questions. It'll come up in the dissent, and I think kind of looms large like over this reaction to Chevron altogether. Another reason, so first reason he says Chevron's inconsistent with the APA. Another reason he says Chevron is just unworkable. He says we've had to continue to clarify and kind of sort out and answer additional questions about maybe when Chevron applies or doesn't apply. Does it displace these other rules or other doctrines? He says it's made it really hard for courts to do their job because of having to kind of constantly respond to these questions about what Chevron means. And he says, once again, it impedes the basic function of saying what the law is. That trying to kind of figure out all these other procedural pieces of the doctrine just makes it really hard for them to do their job. Most importantly, and kind of related to the first point, all throughout the opinion, there are lots and lots of statements about judicial authority and the specific role and unique role for the courts within our system of government. Chevron, he says, improperly gave agencies the authority to resolve ambiguities in laws that they execute. That authority rests with the court and the court alone. there are lots of cites to a decision called Marbury versus Madison, which is kind of an initial, I don't mean this in a critical way, but sort of a power grab by the court back in 1803-04, where the Chief Justice at that time was really carving out the role for the courts within the system of government, that, hey, the courts, they're not just this kind of afterthought, and it's all about the executive and the legislative branch, but the courts are really a co-equal branch of government, and we have jurisdiction over certain disputes, and we have the power to review and resolve those disputes. And so Justice Roberts, throughout the opinion, is citing back to that case, which is probably not surprising because there is a phrase in Marbury versus Madison, or a sentence, that says, "It is emphatically the province and duty of the judicial department to say what the law is." That is kind of the overarching message of the majority opinion in Loper-Bright, that there's a role for the courts. What the agencies have been doing is kind of stepping on our turf. We're the ones to say what the law is. Although Chevron is dead, the majority opinion kind of does a couple things that I think are worth noting. So it does not say that courts are fully prohibited from considering agency interpretations of statutes. There are other decisions kind of throughout the history of the court's jurisprudence where the court looked at executive branch or agency interpretations, and one case is known as Skidmore, and so now instead of Chevron deference, there's this idea that we maybe have Skidmore respect, where we respect in some way what the executive branch or what agencies thought in trying to resolve some of these ambiguities. The language from Skidmore kind of says the following: "The weight of such a judgment in a particular case depends on the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all of those factors which give it power to persuade, even if it lacks the power to control." So kind of making sure that the agencies and the executive branch sort of know their place, but saying, you all might have some good ideas, and it might be in our interest to occasionally kind of see what you're doing over there and see how you've interpreted your own authority and some of these statutes and agency behavior. So instead of Chevron deference, we're in this world now of maybe Skidmore respect remains. Also, importantly, the court said, we know that many, many thousands and thousands of federal court decisions have cited to and relied on Chevron. I believe it was something around 18,000 at the time of oral argument, which is a lot. It's one of the most cited cases kind of in American jurisprudential history. And the court kind of recognized that it would, beyond what it's already doing in the decision, it would really, really upend things if it said, wow, every decision kind of since 1984 that relied on Chevron is now gone. It says those decisions aren't directly overruled. We are just changing the interpretive methodology going forward. And so that includes Chevron itself. So that decision that we talked about with the bubble approach, the court says that's okay. Maybe they've reached the right outcome, but we just don't quite like how they got there. So this interpretive methodology changes going forward. Existing decisions remain intact. And that's important to remember because the outcome of that initial Chevron case was deregulatory in nature. And so that kind of aligns with a lot of the political views and views that many of the justices have that are just generally skeptical to maybe even hostile towards agencies in general. Okay, that was the Roberts majority. I'm going to touch briefly on two concurring opinions and the dissent. So one concurrence came from Justice Gorsuch, who some of you may know, his mother was actually the administrator of the EPA during the Chevron decision. Just a fun fact. He wrote a concurring opinion almost as long as the majority opinion that spent a lot of time walking through and kind of defending why the Loper-Bright decision isn't an affront to a concept known as stare decisis. Stare decisis kind of is a term meaning let the decision stand or allow past decisions to stand, also known as precedent. So the idea is if we are to have some stability and predictability based on what courts tell us, we don't want courts to be just kind of swinging back and forth and maybe behaving like some of the other political branches behave. We want courts generally to look back to what their predecessors have done, how they've interpreted laws, and defer, maybe, you might say, or to respect what they've done and try to maintain some consistency. The idea is that precedent really should guide the reasoning unless it was kind of so egregiously wrong at the time that the court has no choice but to step in and say, we are correcting a past mistake, which it said in this case. So that's what Justice Gorsuch spent his concurring opinion doing, really walking through why the Loper-Bright decision, although it is getting rid of Chevron, which has been in place for 40 years, doesn't actually kind of contradict or affront or offend concepts of stare decisis. Justice Thomas writes separately in a much shorter concurring opinion just to say, I agree with Justice Roberts. Yes, there are a number of reasons to get rid of Chevron. I have another one, which is I actually think it's unconstitutional because it violates these principles of separation of powers. So you get some sense that Justice Thomas maybe would have gone a little bit further than the majority went. Notably, the majority didn't bite on that. What happens when right before the opinions are released, the justices are kind of reading various drafts, and there's a little bit of maybe horse trading that goes on to get people to sign on to various opinions. So Justice Roberts would have seen that Justice Thomas was kind of thinking about maybe pushing Loper-Bright a little bit further to say, actually, Chevron violated separation of powers principles and was not only inconsistent with the statute, but actually unconstitutional, and decided not to do that. And that is important when we think about what might happen in the future. So I'll come back to that piece. Lastly, Justice Kagan wrote a dissent where she was joined by two other justices who disagreed with the reasoning and the outcome of the majority. A couple things that Justice Kagan focused on. So one, she really gave examples of specific cases where resolving an ambiguity relies on some sort of technical expertise or scientific knowledge that she's pretty confident that she doesn't have and that her colleagues on the court don't have either. One example is a case in which the FDA who's tasked with regulating biological products, regulates proteins. And the question that the court had to figure out, and that an agency had to figure out, was when does an alpha amino acid polymer count as a protein? She admitted, I'm not even sure that I know what an alpha amino acid polymer is, much less when it should count as a protein. Another example, under the Endangered Species Act, Fish and Wildlife Service must designate endangered species, including, quote, distinct populations of those species. So distinct, what does that word mean? The question that the agency and the court was grappling with is the Washington state population of western gray squirrels distinct from other western gray squirrel populations because it's geographically separated? Is the court equipped to know that? Are they familiar with species behavior in these habitats in Washington state? She says, probably not. Let's have a little humility here, colleagues, and accept that we don't have this hyper-technical specialized knowledge in every single area in which the federal government has to kind of act and regulate. She also didn't want to let the court kind of rewrite history a little bit. So there's a section in the Roberts opinion that talks about how, well, Chevron hasn't really been used, and he kind of gives that as a reason why it's unworkable, that so many, or the fact that it isn't being used is an example of why it's unworkable, or how it's been unworkable, that justices just kind of seem to be hands off. We don't even want to deal with Chevron, it's so unworkable. And she says, well, part of that is because you kind of intentionally enfeebled this doctrine. You were aware that you were critical of it and that many other kind of similarly politically leaning and folks with similar philosophies didn't like this doctrine and wanted to get rid of it. And so by design, you were trying to avoid it so that you could later say, wow, look, it's already kind of on its way to being obsolete. So not so fast. I'm not going to let you off the hook with kind of rewriting that history. And then the last thing she said that is really important to me and kind of where I think a lot of the future debates, discussions, fights will be is with the following. She says, we used to fight about this term ambiguity and when a statute was ambiguous and what that meant. And now it just seems like we've shifted the debate, or we're shifting the fight to talking about respect. So we used to have this deference in the context of ambiguous statutes. Now it seems we're just going to be arguing about when Skidmore respect is owed, and what does it mean to kind of respect agency decisions. I'm not sure, court, that you have really resolved the problem. You've maybe just shifted it to a different realm, is what she says. Okay, I know that's a lot. And I am going to now shift a little bit to try to make some sense of it and give you some thoughts about what this decision might mean. It's still only a few months old. Courts are just kind of figuring out how to work it into existing cases. There are a couple things that I am pretty confident in or think are kind of fairly true, and then there are some others that we may have to wait and see. So one is that Loper-Bright is part of a larger project to diminish agency power and really enhance judicial power, because Loper-Bright didn't just say, we don't like Chevron because it's deferring to agency, so we're just going to get rid of it. Robert's opinion spent a lot of time talking about why it was courts, not agencies, courts who should kind of have this power and function. So it's a real shift here and kind of an enhancement of judicial power. I think that many federal agencies and the White House kind of anticipated this. They saw the writing on the wall a few years ago. They kind of heard more conservative colleagues talking about, being critical of Chevron, and in an effort to maybe kind of preempt what might flow from getting rid of Chevron, EPA and some other agencies have sort of shifted in the way that they undertake certain actions. So instead of kind of arguing in court that Chevron deference is owed and that's why they should win, there's been a little bit of an increase in arguing that, well, setting Chevron aside, our interpretation of the ambiguity in the statute is the best one. And because it's the best, that's why we should win, not solely because of this deference thing. And Loper-Bright didn't go as far as Thomas suggested. So that also means that, in addition to not necessarily surprising anyone, I think, it also didn't say that there is no place or a prohibition on considering agency interpretations. And so I think in light of this, Loper-Bright kind of independently may not have been sort of the earth-shattering decision that some people expected. I think people expected it might say what it was going to say. But it's Loper-Bright paired with some other things that the court has done and has been doing that I think will have the more profound impact. And that's probably where some of the problems will arise. I'll give you a couple examples. There's something called the major questions doctrine. Maybe people have heard of this. But it's another doctrine that kind of says, when the court is considering these questions that have some sort of major economic or political or social impact, there's not really any role for agencies there. It's really, those are the types of questions that should always just go to the court. We don't really need to worry about what agencies think about those, much less really support the fact that they always have authority to act in those areas. There are some specific areas where we're not really sure that we should kind of read into ambiguities authority for agencies to act unless Congress has been really explicit and clear about it. So these so-called major questions, the court says that demands more of a really precise, direct statement from Congress that the agency should be doing X, Y, Z things. This doctrine has been invoked, unsurprisingly, in some environmental cases, especially those dealing with the Clean Air Act and how to curb emissions to address climate change. Another decision that will likely kind of impact the role of agencies was a decision known as Corner Post, also from last term. And in that case, the court made it easier to challenge federal regulations. So normally under the APA, that statute from 1946, there's a 6-year statute of limitations. That's a fancy way of saying that Potential litigants can't just wait forever to bring claims. If you are harmed or you have some disagreement or some injury caused by something an agency does, you need to act on it within this 6-year period. And if you don't, in general, you've kind of waived your opportunity. What the court said in Corner Post was, we're not actually going to start that clock until the plaintiff or the potential litigant is impaired by the regulation. So even if it was a regulation from many, many years ago, if the individual litigant doesn't suffer the harm from it until some period later in the future, that's when the clock starts for them, is from the time that the injury starts. So what that does is it really kind of expands the time in which potential litigants could challenge agency actions. It also means that I think right now at this very moment, there are a number of potential plaintiffs, potential litigants who are thinking about, are there any agency actions from 10, 15, 20 years ago that I might be interested in challenging, especially if I only recently suffered an injury or became aware of some harm that was done to me by that agency action. So that's one thing that I think is very much happening right now. I was listening to a podcast with a couple attorneys talking about how a lot of the big law firms in Washington, D.C. are almost using this as like an advertising point. Have you been injured by something from some years in the past? Come to us. We can help you litigate and kind of challenge that action. That's maybe just kind of a silly anecdote, but I think it kind of reflects a reality of what's happening. Couple other things I think we can expect to see flow from Loper-Bright sort of paired with this broader project of cabining or really diminishing agency power. So this is a big power shift to the courts, but I'm not sure that it actually means we will get better interpretations of ambiguities or better outcomes. And the reason for this is that courts just are not experts in all of these technical and scientific areas in which agencies have to regulate. Not a knock on them at all, but you can just imagine the wealth of knowledge one would have to be able to resolve all of these ambiguities in all of these different areas. And just to give you an example of this, you may have heard about this elsewhere. I'm sure it's a little bit embarrassing for the court, but and they probably feel like people are kind of making a mountain out of a molehill. But just a couple days before the Supreme Court's decision in Loper-Bright, Justice Gorsuch wrote and issued an opinion in a decision called Ohio versus EPA. And broadly, that was a Clean Air Act decision looking at the way that the agency kind of regulates smog. If you've seen any of the brown clouds or in Los Angeles, smog certainly is something that affects air quality. I certainly appreciate when the agency kind of like undertakes actions to address smog. The opinion, I think 4 or 5 times, talked about regulating nitrous oxide instead of nitrogen oxides. Nitrogen oxides are the kind of category of 4 or 5 different pollutants that contribute to or comprise smog. Nitrous oxide is laughing gas. And the opinion actually had to be kind of taken down and then corrected and then reissued. Again, not a direct criticism of the justice. I'm certainly in no better position to be weighing in on these types of hyper-technical scientific decisions, but the fact remains that the justice himself, his clerks, any other justice and clerk who kind of read that opinion before it was issued didn't have the expertise to say, are we sure it's nitrous oxide? I think the term might be something else. It might be a different substance. And I think that's a problem. That might seem like sort of a silly, superficial example, but you can imagine other examples where it's maybe more substantive and really could be an issue. Another kind of impact or consequence of this decision is that acting to address climate change is probably going to be more challenging. There was a decision known as Massachusetts versus EPA, in which the court held that EPA has authority to regulate greenhouse gases, and it was kind of celebrated as a success. It originated with a citizen petition to the agency to say, agency, we think that your authority under this statute includes greenhouse gases, and that's a really important category of pollutants to address because of climate change. EPA initially said, nah, we don't really think so. We're not sure that our authority extends that far. And so it was a victory when the court said, actually, EPA, yes, it does. You have authority to regulate those substances. EPA had largely kind of used the Clean Air Act as a tool to try to address greenhouse gas emissions from vehicles and from those stationary sources I talked about earlier. The Supreme Court has been, in recent years, a little bit skeptical of this. And in a decision known as West Virginia versus EPA, the court held that EPA's authority under the Clean Air Act did not include requiring something known as generation shifting. Without getting into the details, some of the elements of President Obama's Clean Power Plan included tools that would kind of shift production from fossil fuel-based energy sources like coal, oil, and gas towards cleaner forms of energy production. So there were 2 out of kind of 3 main components of the Clean Power Plan that were so-called generation shifting. And the court said, no, we don't think the act clearly authorizes that. So that is beyond the scope of your authority, EPA, which is really tough because that is one way that within the structure of the Clean Air Act, the agency can try to address climate change. And it just has gotten a little bit harder in light of the Loper-Bright decision and some of the other kind of anti-agency actions or decisions that the court has issued. One thing that is maybe helpful, at least for the time being, to clarify, Loper-Bright was talking about a specific situation involving ambiguities in statutes. So in laws that are passed by Congress, when there are ambiguities there, that's the kind of the factual situation that both Chevron and Loper-Bright were dealing with. There are other circumstances involving regulations. So statutes come from Congress. Regulations are these rules that are promulgated kind of by the agencies following a process that the APA laid out. The analytical framework and the deference that is owed to agencies in the context of interpreting their regulations remains intact. So we may see an effort to try to execute agency function perhaps a little bit more heavily through regulations or in an area where there is still maybe some degree of deference owed. It's possible that that is also maybe on the chopping block or maybe kind of in the eye of or a target for folks who are looking at ways to kind of diminish the activity of agencies. But for now, it's kind of known as our deference based on the name of the decision. That remains intact. So one other area to mention, and I am running low on time, so I want to make sure I just briefly mention this and then open it up to questions, has to do with public lands. On the drive out here, I always loved just driving out here and going through Glenwood Canyon and then sort of opening up into these really vast, impressive, beautiful western landscapes. We are really lucky to live, at least in my opinion, in this part of the country where there are so many public lands. Obviously, a lot of different people have different interests in the uses of those public lands. And are rightfully kind of concerned with how the federal government and the agencies tasked with managing those lands carry out their function. BLM manages most of the agency of the federal government's public lands. The Forest Service and some others manage others, but BLM is kind of the primary agency, I would say. And recently they issued a new rule that would kind of help steward and guide public lands management going forward in the future. And this rule does a couple things that are notable, and for folks who are kind of interested in moving away from more extractive uses of public lands and towards more protective uses, there was a lot for people to celebrate in this rule. Conversely, if you are a person who is interested in other uses of public lands, you may have been pretty disappointed by this rule. So a couple things the rule does. One is that it essentially defines conservation as a use of public lands. So the major public land statute is FLPMA, Federal Land Policy and Management Act, also passed in the 70s when a lot of these statutes were passed. But that law kind of sets the policy for how public lands should be managed, and it's under this sort of multiple use and sustainable yield approach. Those phrases have somewhat precise meanings, but the idea is we can have mixed uses. We get that there are lots of people who want to do different things and have different interests in our public lands, and BLM, you should do your best to try to kind of balance and harmonize all those various uses. You at least need to kind of take them into account, recognize that one use is not necessarily better than the others in all cases. What the rule did is that it kind of expressly defined conservation as a use that is equivalent, not superior to, but equivalent with other uses. So folks may use public lands for things like oil and gas extraction or grazing, if you have any type of livestock. Maybe people are interested in recreation. There's tons of fantastic recreation that I really enjoy on public lands. Maybe you're interested in habitat conservation and species that are really special to you, and you recognize that public lands can be an important home for them. This rule says, out of all the various uses, conservation should kind of be an equivalent use. And then to help achieve that goal, the rule expands or kind of clarifies 5 different tools to help achieve it. And I won't go through them all, but just a couple. So one is the inclusion of leasing for sort of restoration or habitat mitigation purposes. Previously, land would generally only be leased to someone that had the intent to either extract oil and gas or otherwise develop the land in some way. These leases are not purely just to kind of prevent anyone from accessing or using the land, but they kind of offset other types of development or other uses on the land and carve out a way to say we are going to expressly lease land for habitat mitigation or restoration purposes. That was kind of a novel, an important development for people who are interested in conservation. And another one is the kind of creation or the clarifying of processes for these areas of critical environmental concern. Congress created these areas, ASECs or ACES, directed BLM to prioritize their identification and protection way back when it passed FLPMA, like 50 years ago. And the procedures for kind of designating these areas had been just kind of slowly coming along and only partially described or partially codified in regulations and policies. And here, this rule really tried to clarify the policies and procedures for these particular areas that get this special designated status. So this rule, as I mentioned, is something that was applauded by folks who are interested in seeing conservation elevated to kind of the same category of use. But as you can imagine, folks that have other interests in public lands weren't pleased by some of the things in the rule, including some of those tools. I think that the current count is maybe 5 lawsuits in different jurisdictions challenging this rule: Utah, North Dakota, and Wyoming. And this is an area, I've read a couple complaints, it's been a while, but the complaints specifically note that BLM is owed no discretion in this case. And so you can imagine maybe circumstances would have been a little bit different if Chevron was in place or if the courts were inclined to defer to the agency's interpretation of a term like use. Is conservation a use of public lands? So if you are a person who is interested in public lands, those cases are definitely something to follow. You can also reach out to me. I'll be happy to send you updates because I will be following them as well. I really want to be able to respond to questions if you have them. And so I will stop my remarks there and just close by saying thank you so much for having me and for your interest in these subjects. You know, I know it's not Constitution Day, but I'm sort of here in the spirit of Constitution Day and thinking about the way that our government functions, the role for the different branches of government is so foundational. And sometimes the term government, I think, gets improperly abstracted because really it's all of us. We are the people who elect representatives or serve in Congress. We are the ones who are subject to certain rules and laws. And so it's your own interest and your actions that really will help us promote, I think, a government that's more workable for everybody. So thank you very much for your interest and happy to answer some questions and looking forward to speaking with students tomorrow as well.
one of the things that they found, I'm just kind of wondering, the context is how wacky is this going to get? How bad is this going to get? And so one of the things that they found is this really benign regulation, which is one of the things that keeps us the most safe, but it is not in the act. And so, it's not black letter of the law. It is definitely agency interpretation that, is so impactful, but it is not in the law. And so, they were asking, will this get overturned? And it would just be, if it got overturned, theoretically, a new regulation would be put in place in the future, but it would cause such chaos, for the 10 years or whatever it would take to get it put in place. And I'm just kind of wondering what we're thinking about how crazy things are about together.
That's a great question. I'm anticipating a certain degree of kind of chaos or upheaval, although I don't know that it's going to be quite as immediate as maybe I thought or others would have thought, because as you mentioned, these things can take quite a long time. To your point, I think that any sort of when an agency is acting, if its authority is premised on something far away from the statute expressly describing that authority, that's the stuff I'd probably be more worried about. That might be the low-hanging fruit for folks who are kind of interested in maybe challenging some of these regulations or limiting agency authority in certain areas. Those are, probably the things that people will be looking to because they don't rest on as solid of a foundation. And, in theory, we could have a Congress who could respond to help address some of the chaos. And I think kind of regardless of where any of us fall on the political spectrum, the fact that Congress doesn't seem to be particularly functional at responding, in either direction or in whatever direction you may have, just makes me nervous for how the chaos might be addressed or unaddressed. So that's an area where I would hope that the folks who are kind of serving those positions would maybe be more committed to resolving and grappling with hard problems instead of sort of just posturing for the sake of keeping their positions and then preventing meaningful solutions from happening. Because even if there's a solution in place that people don't necessarily like, I think there is a little bit of value in stability and predictability. So it's helpful to get clarity from them. But if they can't respond and we're just left with the other branches of government, that's just doing a disservice to all of us.
Do I hear you saying that anywhere you see a gap, you anticipate at some point there's going to be lawsuits trying to overturn those regulations?
I think it depends on a number of things. So those gap areas are, from a litigator's perspective, if I had clients who were kind of looking for maybe things to challenge, those would probably be, the ones I would look to first. But you'd have to also consider, what's the impact? Because for different industries, sure, maybe there's text in a regulation that seems somewhat disconnected from statutory authority, but if the impact of that is sort of marginal on my bottom line or my shareholders' returns, you'd kind of have to do the cost-benefit analysis of, should we kind of go after that low-hanging fruit even if it doesn't improve things all that much for us, or maybe should we spend our resources thinking about more robust challenges to those parts of statutes that might be a little tougher to get at, or regulations.
All right, any other questions? Well, if you'll join me, I'm sorry, can you go ahead?
I did, recently I was in my speech class, and they listed this Unify America challenge, where it's, they basically set us up on a random video chat with somebody across the country. Ideally, you would have opposing political views, and throughout your entire speech,
interesting. So kind of like some sort of mandatory either civics or subject matter courses. Yeah, I mean, I think that could be really beneficial. I imagine there are some representatives that are elected and are really trying to act in good faith. They feel that they are called upon to serve the public. They are doing their best to kind of proactively learn about, the subjects of the committees they're assigned to or the major issues that they're going to be considering. And then, sometimes, unfortunately, I think there are other actors that maybe public service is not always kind of the leading reason, to be in that office. Maybe it's a reason, but they may have other interests too. But education is certainly a piece of it. When you think about some of the examples that I gave of the technical issues that courts and agencies are asked to consider, Congress has to think about those things too. And so, something like that, I think, could be helpful. It may help, just in the interest of time to try to target it in a way. And there probably are some things like that that are going on. The other thing you mentioned, though, I think is really important, and that's just talking to people who maybe have different views than you do. One thing I think about kind of working in environmental law, to me, I'm just interested in kind of bringing in as many people to the cause, and especially an issue like climate change, as possible. And it's okay if we don't agree on 100% of things. One example, kind of in the public lands and maybe wilderness space, there are some folks within environmental law who are kind of gravitating towards it as like animal rights people, and there are other people who are hunters and who are fishers. They probably have very different views on that narrow issue, but on other issues, they may actually share certain perspectives about the importance of kind of protecting wilderness areas and conservation generally, maybe for different reasons. But it's disappointing and unfortunate, I think, that sometimes those few areas of disagreement prevent us from being able to find any area of common ground because we're just holding out for perfection instead of, trying to say, what, we're at 70% or we're at 80% agreement and this is actually pretty good. Sure, both sides might be a little disappointed, but at least we've got something instead of everyone holding out and kind of staying in a gridlock. So I think the idea of just talking to people that have different perspectives, seeing people as people first, and then it makes it easier to kind of talk through areas where you have disagreement is really important. And I'm glad you did that, and I want to do a better job of that myself.
Anyone else? Well, if you please join me in thanking Professor Matsumoto again for coming out.
Thank you all so much.